Good morning. How's everybody doing? Let's do some more jury charge in a civil case. I'm just going to read it, and I may go fast, I may go slow, but let's see how we do. Ready? Ladies and gentlemen of the jury, after the attorneys have presented their summations, you will go to the jury room. You will then select one of your members as your presiding juror. It shall be your presiding juror's duty to preside over your discussions of and deliberations upon the case, and vote with you. You will have this charge with you in the jury room, and shall refer to it for guidance during your deliberations. Suitable forms for your verdict are attached hereto. This case is submitted to you by asking questions about the facts, which you must decide from the evidence you have heard in this trial. You may render your verdict upon the vote of 10 or more members of the jury. The same 10 or more of you must agree upon all of the answers made and to the entire verdict. You will not therefore enter into an agreement to be bound by a majority or any other vote of less than 10 jurors. If the verdict and all of the answers therein are reached by unanimous agreement, the presiding juror shall sign the verdict for the entire jury. If any juror disagrees as to any answer made by the verdict, those jurors who agree to all findings shall each sign their verdict. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court as it is given to you in this charge, and you are bound to be governed thereby. While you should consider only the evidence in this case, you are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the testimony and evidence in the case. You shall consider only the evidence and exhibits presented here in the courtroom through the witnesses who have testified. If you want to have the exhibits with you in the jury room for your deliberations, advise the bailiff. In deliberating on this case, you shall not talk to anyone except the members of the jury about it until you have been finally discharged from service on this jury. If you want to communicate with the court, explain what you want in writing and deliver your message, signed by your presiding juror, to the bailiff, who will deliver it to the court. Do not orally explain to the bailiff what you want. A fact may be established by direct evidence or by circumstantial evidence, or both. A fact is established by direct evidence when proved by documentary evidence or by witnesses who saw the act done or heard the words spoken. A fact is established by circumstantial evidence when it may be fairly and reasonably inferred from other facts proved. When the contract of employment is for a term as opposed to at will, the employer has the burden of showing good cause for the discharge. If an employer wrongfully breaches a contract for employment prior to complete performance, the employee may recover his salary due for the full term of the contract, which in this case is 6 months, should you find any such breach. But if an employer is warranted in discharging the employee cannot collect the salary accruing to him after the date of his discharge. In discharging your responsibility on this jury, you will observe all in the instructions which have previously been given to you. I shall now give you additional instructions which you should carefully and strictly follow during your deliberations. Manner of deliberations. 1. Do not let bias, prejudice, or sympathy play any part in your deliberations. 2. In arriving at your answers, consider only the evidence introduced here under oath and such exhibits, if any, as have been introduced for your consideration under the rulings of the court. That is, what you have seen and heard in this courtroom, together with the law as given you by the court. In your deliberations, you will not consider or discuss anything that is not represented by the evidence in this case. 3. Since every answer that is required by the charge is important, no juror shall state or consider that any required answer is not important. 4. You must not decide who you think should win and then try to answer the questions accordingly. Simply answer the questions and do not discuss nor concern yourselves with the effect of your answers. 5. You will not decide the answer to a question by lot, or by drawing straws, or by any other method of chance. Do not return a quotient verdict. A quotient verdict means that the jurors agree to abide by the result to be reached by adding together each juror's figures and dividing by the number of jurors to get an average. Do not do any trading on your answers. That is, one juror should not agree to answer a certain question one way if others will agree to answer another question another way. 6. Unless otherwise instructed, you may answer a question upon the vote of 10 or more jurors. If you answer more than one question upon the vote of 10 or more jurors, the same group of at least 10 of you must agree upon the answers to each of those questions. 7. It is your sworn duty as jurors to discuss the case with one another in an effort to reach agreement if you can do so. Each of you must decide the case for yourself, but only after full consideration of the evidence with the other members of the jury. While you are discussing the case, do not hesitate to re-examine your own opinion and change your mind if you become convinced that you are wrong. However, do not give up your honest beliefs solely because the others think differently, or merely to finish the case. These instructions are given to you because your conduct is subject to review the same as that of the witnesses, parties, attorneys, and the judge. If it should be found that you have disregarded any of these instructions, it will be jury misconduct, and it may require another trial by another jury. Then all of our time will have been wasted. The presiding juror or any other who observes a violation of the court's instructions shall immediately warn the one who is violating the same and caution the juror not to do so again. After you retire to the jury room, you will select your own presiding juror. The first thing the presiding juror will do is have this complete charge read aloud. Then you will deliberate upon your answers to the questions asked. After you have arrived at your verdict, you will notify the bailiff that you have reached your verdict. All right, that's almost 7.5 minutes of jury charge at different speeds. Hope you enjoy. Bye-bye.